Eric and I do a lot of the on-the-ground trial work for TxDOT, and so we do a lot of time, spend a lot of time preparing engineers, right-of-way agents, appraisers, everything else for these kind of cases. And I know most everybody here knows that the trials generally revolve around just the appraisers. The appraisers, the land planners, those folks are the ones that are testifying. We have seen recently a rise in challenges to the state's right to condemn property, and that's when the engineers become much more important than generally, and that's when the right-of-way agents also come into play. And so that's what we want to talk about today. While, again, appraisal testimony makes up 90% of the work that we do, it's a really important 10% that can determine whether or not we actually get to acquire property. So as you can see, both engineers and right-of-way agents are potential witnesses. And the areas of testimony include generally the engineering stuff, schematics, construction plans, that sort of thing, and then public use and necessity, which we'll talk about with the right to condemn property. Right-of-way agents will usually testify about compliance with the statutory requirements. And then at the very end, we're going to talk just briefly about common areas that we see with witnesses in general, depositions, and emails. Basic testimony for engineers. In every case, an engineer is going to testify at the commissioner's hearing usually, and we'll talk about the design of the project, why we need this particular parcel, what's going to go on out there once the project is in place. Oftentimes you'll be asked to offer opinions about access management, whether the driveway is going to be there in the after, is it safe, that sort of thing. All of those come into the realm of just normal, everyday engineer testimony. And as the last bullet point says, we always want the testimony focused on safety. I always say in preparing my engineers that Jesus loves the little children. And we want your testimony focused on keeping those children safe when they're out driving on the roadways. So every step of the way, we want the engineers focused on safety and how we're making this road better for the traveling public. In the case where the state is having its right to condemn property challenged, the engineer, again, becomes incredibly important because you have to be able to say what the public use for this project is and what the necessity is for this parcel. And that is testimony that is crucial to the state actually being able to acquire property. If we can't offer a public use for the project and a necessity for this parcel, then the court should in fact rule against us and say you don't have the right to condemn this property. So that's why we always have to have that public use and necessity testimony there ready to go with our engineers. And engineers need to be able to say that without hesitation. This is what we're doing, this is why we're doing it, and this is what we need this property for. If we can't do that, then again, we can't condemn the property. We're going to have to pay the landowners their attorney's fees, and we're not going to be able to build the project as it's designed because we won't have that particular piece of land. This next slide is a quote from an actual trial that I was involved in Dallas County. And the landowner's attorney asked my engineer, why are you taking the portion along the east side of the property, not just along the north where you're actually widening the roadway? My engineer, as you see there, answered, I'm not sure we'll use all of that land. We may not need it all. That's a bad answer, okay? That's why I have my next slide there. When I heard that answer, opposing counsel looked down the counsel table at me and mouthed, really? And he couldn't believe it any more than I could because at the commissioner's hearing, my engineer had answered the question correctly, and our preparation before trial, he had the answer to that question, all at hand. He just drew a blank on the witness stand, wasn't sure what to do, and just said, I don't know, we may not need it all. Wrong answer again. We had been trying a really good case up to that point. He was the last witness, and after that, the jury came in on the landowner's number. And when we talked to the jurors after the fact, one of them said, we were with you up until that last guy talked. And that last guy talked, if you don't need the land, you shouldn't be taking it, and we're going to give them everything they asked for. And so in that case, they weren't even challenging the right to condemn. It was just a valuation trial, and he was up there to talk about the design of the roadway and what we were doing. And the correct answer was we're adding in an access lane there to get onto the freeway. And he just forgot that and thought it was just a widening project. And so it was a really bad day for us at that point. And those are the days we try to avoid.
And luckily for the right-of-way agents, there's a whole lot less of a chance for you to get the failure slide because you're not going to be testifying at trial on a valuation issue. Now, however, there is the possibility that you would be testifying at a right to take challenge. And as Clint said, these seem to be kind of popping up a little bit more and more than they have been in the past. Generally, whenever TxDOT just had the traditional build of the roads, people weren't trying to fight the right to take, because it's the State Highway Department acquiring property to build a roadway. However, now with the new funding schemes that we have, more and more landowners' attorneys are looking at it as a way to possibly get a little more leverage for whenever it comes time to close, to settle a piece of property. The majority of the landowner attorneys I've talked to, it doesn't seem like they really think they're going to get anywhere with it, but they still go just in case they get that one judge who gives it to them, and then it just, puts us behind the 8 ball. And so that's one of the issues that we need to consider. Also, with the right-of-way agents, you're pretty much the first line out there who is talking to the landowners. So just keep in mind whenever you're talking with them that you're not promising them anything. Finally, be aware of issues when you're hiring and communicating with experts. We're going to get into a little more detail, but pretty much anything you do, anything you put in writing is going to be discoverable. So just always have that in the back of your mind before you write anything down. Whenever we're having these right to take trials, we had one, I guess it was in May of this past year, up in Tarrant County, and it came down, the judge was he was a little beside himself to find out why opposing counsel was even filing this. We went through the whole dog and pony show, and they came back, and we did have the right to take. But with that, we had one of the right-of-way agents have to give his deposition, and he did a very good job. What you need to be prepared for is just make sure that you have all of your documents all set up. You need all your ducks in a row. Make sure your file has the offers, the appraisals, the landowner's bill of rights. Make sure you have the green cards. Make sure you have proof that you sent those documents to the landowner, because it's very document intensive on that part of it. Also, be prepared to testify that you're meeting all of the requirements of the property code. Like I said, communications with the landowner, documents, and that the service, and that you followed all the timelines. That's very important also. Next we have is expert contracts. Whenever you're hiring the experts, make sure that you write in the correct scope of work. And it says problem statement here. We'll go over that in just a second, because unfortunately that is a real world problem that we had about a year or so ago up in a trial in North Texas. As I said, all communications are discoverable, so be very cognizant of that. And when you review the reports, please know that anything you write down is going to be discoverable. So if you print out a copy of their report, you jot a note on it, that's discoverable, is going to be turned over to the other side. Now back to the first one, the scope of work issue. As you can see here, this is just a standard right-of-way work order that TxDOT was using. And if you can see right there with the laser pointer, it says, this assignment is to value the part taken in the fee simple and damages, if any, to the remainder track, also cost to cure damages for refencing of the remainder. Pretty standard, no problems there. Now, if we go to the next one, this is the one that we had at trial, which was unfortunately exhibit number 9. If you look down at the bottom, you see it just says, estimate the value of the part taken and cost to cure damages. It says nothing about damages to the remainder. We were able to put the appraiser on, to which he said that he looked at it and he determined if there were damages to the remainder. However, the opposing counsel made a lot of hay out of this, saying that TxDOT was informing their experts here to not find damages on this piece of property, which he did not find damages, but it was only because it was 4 acres out of a 100-acre tract. But the jury really grabbed onto that, and they came back on the landowner's number.
We're out of time here. I want to skip ahead to one last slide. With a lot of the deposition talk, if you're going to get deposed, as Susan said, if you work for TxDOT, you'll have one of us there with you. We will prepare you for that at that time, so I won't be doing that. But because emails are so dangerous in litigation, I want you to all be aware of emails. Whatever you send to an expert witness is always going to be produced, as Eric said, or discoverable. A lot of times, emails within TxDOT will also have to be produced, so please be cautious of what you are sending. We had a situation on a project that Don worked on in Dallas with us where this email was sent out by a TxDOT engineer to other TxDOT engineers and ultimately got produced. And as you can see, the litigation was referred to as the price of poker going up. This was a case where we had offered $2 million. The landowners were asking for $40 million because they had a 17-story office building that was 7 feet from the right-of-way. And the question was, are these slant shafts that are going to be into our new right-of-way, or are they vertical shafts that are stabilizing the 17-story office tower? And they didn't know. And they said, if we don't know that, and if they actually are slant shafts and we've condemned them, then we're going to have to, pay for that. But instead of saying we're going to have to pay for that, we wrote the price of poker just went up. This is very damning for us in front of the jury. We don't want this to ever be blown up this big in front of, citizens of Texas determining how much we have to pay to acquire a property. So please, please, please be very cautious and very aware of what you're doing when you're sending emails out there related to cases that may wind up in condemnation. And at the stage where they generally are with you, they're almost always of the potential they may wind up in condemnation. So please be very, very cautious of that. And let us know if you have any questions otherwise. Thank you all.